This story began in the middle of the night, in the middle of Adelaide, in the middle of the 1980s, in the middle of the road. Stramare operated a fruit and veg store, and they used to restock every morning around 1 a.m. At that time, there wasn't much traffic about. There was nowhere really to park the truck, so they left it parked on the road with the lights on and the hazard lights flashing. The occasional passing car would see the truck and go around. Unfortunately, Mr. March didn't see the truck. He didn't see the truck because he was plastered, hammered. He had a blood alcohol level of at least 0.18. He was speeding, ran a red light, smashed into the truck and was injured. In negligence law, it's fundamental that even if you have a duty of care, a breach of duty, and harm, you still have to show that the breach caused the harm. The court often asked, would the harm have happened but for the breach? In other words, would the harm still have happened even if the breach had not occurred? If the answer was yes, then liability was not made out. The but-for test really only worked well when there was just one cause of the harm. It was designed to allocate responsibility to one party. How does it work in a situation like this one, where you could say the harm wouldn't have been caused but for the position of the truck on the road, and you could also say the harm wouldn't have been caused but for the driver's intoxication? The Court of Appeal had applied the but-for test and found that Mr. March bore full responsibility for his own injuries. He appealed. The High Court found that Stramare did have a duty of care. He ought to have foreseen that inattentive or even drunk users of the road might not see or avoid the truck. Stramare's failure to take adequate precautions by moving the truck off the road had been one cause of Mr. March's injuries. Chief Justice Mason said the second respondent's wrongful act in parking the truck in the middle of the road created a situation of danger, the risk being that a careless driver would act in the way that the appellant acted. As a result, liability for March's injuries was apportioned between the two parties.